So good morning and welcome to AT Talks, a collaboration between the Michigan Assistive Technology Loan Fund and Disability Rights Michigan. I'm Tracy Strading, Director of the Michigan Assistive Technology Loan Fund. I'm going to start with a few housekeeping items. Please type your questions into the Q&A or chat boxes or raise your hand so that we can unmute you to ask your question aloud. You may enter your questions during the presentation, but they will be addressed at the end. As I said, we have quite a lot of information to get through. If you're using a screen reader, I'll be dropping a PDF of the presentation into the chat shortly. And we also have real-time captioning. Thank you, Bo, for that today. We'll drop a link in there for that again as well. So I'm happy to introduce our speakers. Anna Kosolova. Nope, I did it wrong. Kolosova. I practiced to make sure I did it correctly. She's a staff attorney at Disability Rights Michigan, where she represents individuals with disabilities in Medicaid administrative appeals. She joined DRM as a staff attorney in 2023. Prior to that, she represented domestic violence survivors at Family Law Project in Ypsilanti and low-income taxpayers at Accounting Aid Society in Detroit. And a familiar face to many of you who regularly attend the AT Talks, Sarah Healey, an advocate at Disability Rights Michigan. She's worked with the disability community for over 25 years. Prior to joining Disability Rights Michigan in 2016, she worked as a recipient rights advisor for community mental health and as a supports coordinator with the ARC in Massachusetts. Today, Anna and Sarah will present on obtaining assistive technology through Michigan's Medicaid Habilitation Supports Waiver and the MIChoice Waiver. Take it away.
I think it's up. Can everyone see the PowerPoint?
There you go. That's perfect. Okay, well, I'm going to start this thing off. Thank you, Tracy, for the wonderful introductions, as always. I love being here. Today, we're going to talk about obtaining assistive technology through Michigan's Medicaid's Habilitation Supports Waiver and MIChoice Waiver. Next slide. So first, I want to go over the agenda, just so you have an idea of what we're going to do today here with you. I'm going to begin with a brief introduction about Disability Rights Michigan and the services we provide. Then I'm going to jump right into an overview of the HAD Supports Waiver and the MIChoice Waiver and discuss what is covered under those waivers as far as assistive technology goes. There'd be medical equipment and supplies, environmental modifications, and goods and services. Then after that, I'm going to discuss the process for requesting assistive technology and highlight some tips for success. And then Anna's going to take over with probably the larger portion of this and discuss how to appeal denials of AT when you're appealed under the HAB waiver or the MIChoice waiver. And then finally, we'll end with questions, and we expect there'll probably be quite a few. One note I did want to say, our slides are loaded with information. And as Tracy said, the PowerPoint is available in the chat, but we really wanted to include everything on the slides because a lot of it comes directly from the Medicaid provider manual or legal brains like Anna. So very detailed information. But go ahead and go to the next slide, please. Okay, so a little bit about Disability Rights Michigan. We're Michigan's federally designated protection and advocacy agency. We provide free legal services and advocacy and information to protect and promote the rights of people with disabilities in Michigan. We assist with issues such as abuse, neglect, employment discrimination, housing, access to services, access to AT. We do quite a bit. So if you need help with any of these types of issues, you can give us a call and speak with someone in our intake and information referral department, or you can go to our website and we'll provide that phone number and web address at the end of this. Just want to mention we serve the entire state of Michigan, so wherever you live in Michigan, you can give us a call. And we receive probably about over 4,000 calls a year to our intake information referral department. So we're pretty popular and we help out a lot of people. All right, next slide. Okay, so before I get into the waivers and waiver coverage for assistive technology, I think it's important for me to highlight what types of AT are covered under your regular state plan Medicaid. Before you can access any AT under waivers, you first have to try to, if it's something that's covered under the state plan, you would have to get it under the state plan. So what's included under state plan? Durable medical equipment. That would be things like walkers, wheelchairs, hospital beds, items that could stand repeated use within the home. Prosthetic devices and orthotics, things like artificial limbs or special braces, communication devices, speech generating devices, eye gaze, and then diabetes supplies. There's probably more to this list, but this is kind of a quick list of examples of the types of items you could get under the regular state plan Medicaid. Go ahead to the next slide. Okay, so here we go. There's several different waivers in Michigan, but the two home and community-based waivers for assistive technology that we're going to cover today are the HAB supports waiver and the MIChoice waiver. Both of these waivers are available for folks who are over 18 years old. So a little bit about the HAB waiver. I say HAB, it's a Habilitation Supports Waiver. Sometimes you'll see it abbreviated as HAB or HSW, but throughout this, I'm just going to refer to it as HAB. It's for individuals with developmental disabilities. And without HAB services, these folks would require a level of care of an intermediate care facility. And these services for these folks are provided through community mental health. So if you're interested or think you might be eligible for HAB support waivers, speak with someone at your local community mental health agency. Now we'll go on to the MIChoice waiver. This one's a little different. It's for individuals who meet the medical functional criteria for nursing home level of care. Again, it could be any age above 18, so you don't have to be elderly to be on the MIChoice waiver. And without the MIChoice waiver services, individuals would require nursing home placement. And these services are provided through MIChoice waiver agencies, which are typically the area agency on aging. So you can go onto the MDHH website to see a map to see which agency you need to contact in your area. So both of these waivers include these three services that provide for assistive technology: be medical equipment and supplies, environmental modifications, and goods and services. And in the next slides, I'm going to go through each of these three services and explain the items you'd be able to get and how to go about getting them. Go ahead to the next slide, Anna.
I will, but I just want to chime in with one thing. It is possible to qualify for both the HAB waiver and the MIChoice waiver, depending on what your particulars are. And so if you do qualify for both, you can pick which one suits you best. You must pick one. You can't do both. But it's worth talking about things like wait lists and covered services to decide which waiver would be best for you.
Thanks for that, Anna. Yes. Okay, so first we'll go over medical equipment and supplies. Again, this is available under both waivers. You'll notice the name is different. Under the HAB waiver, it's called Enhanced Medical Equipment Supplies, and under MIChoice, it's called Specialized Medical Equipment and Supplies. So this covers things that provide support for activities of daily living and communication, to be able to control your environment and communicate with the environment around you. It's items that provide direct medical or remedial benefit. So this would be things that are related to a person's medical or functional needs. And I'll go into the examples here in the next slide. For any item you get under this, you would have to make sure it's documented in your service plan. So for a CMH, it would be an IPOS, individual plan of service, or if it's MIChoice, it would be the individual plan of, probably not service plan. I'm not sure if I'm getting that right. But it needs to be documented in your service plan. This would include coverage for related supplies, any initial training, and any maintenance costs that is needed once you get the AT to your home. And another couple of requirements is equipment must meet applicable standards of design, manufacture, and installation, and items must not be covered by the Medicaid state plan or other insurances. Remember, I just went over the state plan and types of things that are covered there. So yeah, if they're covered under the state plan, you would access them through that. Or other insurances, you might have Medicare or a secondary health insurance. It couldn't be covered under that. Okay, next slide. Okay, here's some examples of some of the different types of medical equipment and supplies you can get under HAB and MIChoice. Got a few pictures there. We got items for mobility and transfer, talking ceiling lifts, items that aren't covered by traditional Medicaid, shower benches, environmental control and communication aids, voice-activated call systems, custom environmental control units for doors, lights, and heating and cooling for those folks who can't get up and just flip a switch. Daily living aids, programmable, I'm not even trying to say that word, medication dispensers, adaptive kitchen devices, positioning and support equipment, types of support systems that for people who can't use just a standard wheelchair. And then also medical support systems would be battery backups for ventilators or oxygen machines, adaptive switch operated hospital beds. I mean, the list can go on, but these are just a few of the examples. And then finally, my favorite, vehicle modifications. This does not include the purchase or lease or routine vehicle repairs. Now, vehicle modifications is new under the MIChoice waiver, probably within the last year or two. I actually helped a young lady get approved for vehicle modifications under MIChoice, and I'm telling you, that was like an amazing feeling. Not only for her, but for me too, because I mean, it opened up just a world of independence for her where she could finally start getting out into her community because she couldn't rely on just the regular transportation. So she got over $20,000 of vehicle modifications to her new van. So very exciting. So just keep in mind that is now available under MIChoice as well as HAB. All right, next slide. Environmental modifications. This is going to include things like widening doors, adding on ramps, accessible bathrooms. So these items must be necessary for the health, welfare, or independence of the person who needs them. They must be cost effective. And I'll talk a little bit more about cost effective and what that means in the next slide or two here. It must be reasonable, and other funding sources must be explored. And again, other funding sources, first you're going to look to your other insurances if you have any, and then look at loans, grants, other possible funding sources in your area or in the state. Any modifications that are done must be tied to the participant's plan of service. And I'm going to keep saying this over and over again, it's extremely important. Anything that you're asking for, it needs to be in your plan of service, either related to a goal or a goal itself, but it needs to be in the plan of service. Any modifications must meet building codes, construction standards. So if you're getting any doorways widened or lifts put in, it's going to be done by a professional. And any adaptations must be for the person's primary residence. So even though it might be great to have a ramp over, at your neighbor's house, so you can go visit them whenever you want, Medicaid's not going to pay for that. It's only for your primary residence. And then documentation is required in the plan of service. Like I said, it needs to be written into your plan of service. A couple of examples, like I already said, ramps, doorways, door openers, smart home systems, specialized electrical plumbing systems for medical equipment. There's a lot of different things that could fall under this. Okay, next slide. Goods and services. This is the last area I'm going to talk about. This is kind of a catch-all for the things that aren't covered under the other service areas. So these are only available for participants choosing the self-determination option. If you're using self-determination, you know what it is and you know what I'm talking about. If you're interested in self-determination, I highly suggest speak with your supports coordinator or case manager. And so the purpose is for goods and services to provide participants with equipment and supplies not otherwise covered that meet the goals identified in the person-centered plan. So these items must decrease the need for other Medicaid services. And this should be or promote community inclusion. They should increase the participant's safety in the home or the community, not be available through other funding sources, be documented in that plan of service. Again, got to have it in the plan of service. And they can't be items that are experimental or prohibited. So I only have a few examples here because this is not something I've assisted anyone with, but examples I came up with: specialized alarm clock, maybe adaptive clothing, communication software, And if there's anyone watching this who wants to throw in some other examples, I'd really appreciate it, because I was coming up short on those. But again, must be under the self-determination arrangement. Okay, next slide. Okay, now that I've gone over all the different types of AT that you can access under these two waivers, I want to talk a little about the process. This is really important. I mean, you got to follow the process if you want to get the item approved. Each step is just as important as the last, so I'm going to go through them. There's 6 steps. And we'll start with step 1, identify the need. Consider how assistive technology could help increase your independence, ensure your safety, or support your daily functioning. Think of items that maybe that you wish you had, but you don't have, but they would help. That was a really bad example. Anyway, and then once you identify that need, talk with your supports coordinator or your case manager. You're going to want to have that AT added to your plan of service. This would include required steps to obtain the AT and the person responsible for AT. And I think it's really important. I like the idea of putting the person responsible for each of the steps, because I've worked with folks who, mom's gonna go and get the denials from the other funding sources. Case manager is gonna go and get a couple bids, and it's some confusion over who's gonna do what. So for accountability purposes and to know who's doing what, have the name of the person responsible for each of the steps. And then also you might want to put a timeline, how long, within 3 months, I'm going to get the 3 bids for the vehicle modifications. So it's really important. Have it in the plan of service. Okay, and then step 3, obtain documentation to support the medical or functional need. This again is paramount to getting your device approved. This is going to include likely a physician's prescription, and or most often you're going to need therapist evaluations and recommendations. This might be a physical therapist or an occupational therapist that might try out different devices with you to see what best fits you and suits your needs. And then for environmental modifications, you probably need to get an assessment or bids from licensed professionals, so that can take some time too. So you want to get all this documentation together before you even move to the next step. Go ahead to the next slide. Okay, step number 4. You've got all your documentation together. Now you want to double check and make sure you've been able to explain the cost of effectiveness of the AT that you're hoping to get. Now consider the cost of an alternative piece of AT. Might be cheaper, right? It might be cheaper in the beginning, but then you got to think about what additional therapies might you need to use this cheaper device. And in the end, the price might end up being even higher than the original, more expensive piece of AT that you wanted. And it's important to have this documented, because if someone gets denied because the cost is too high for the item, and that's suggested they should go with a lesser cost item, it's good to have an explanation of why that lesser price item is going to be more expensive in the long run. Additional PT or OT needed, or additional speech therapy needed. So, and maybe Anna can help me out with this a little bit more to talk about the cost effectiveness, but you're going to want to have that written up by either the doctor or one of the evaluators in with your documentation that you're submitting. I mean, it's good to head it off before, ALJ or a judge points out to you, wait, you should be getting the lower cost one. No, you have your evidence here why going for the higher cost one is actually ends up being cheaper. And then after that, you're going to explore your alternative funding sources. Once again, it might be you, the person who's looking for the device, might be a loved one helping you, might be your supports coordinator, but you need to explore those other funding sources and have documentation that you've been denied. A lot of times you'll have to get a denial from Medicare, or maybe a statement from your private insurance that it's not an item they'll cover. And then you also need to explore any AT grants or housing grants or things that might help you to pay for these items before you ask Medicaid to pay. And then finally, once you have all your documentation together and all your prescription, your funding sources, all of that together, you're going to submit it to the waiver agency. You want to make sure that everything is signed and ready to go. And then it's in their hands. Now, a couple of tips I have on this. Once you submit it to your waiver agency, I highly recommend you keep following up. Follow up with your supports coordinator, even if it's weekly. I mean, I've done it for people. Just, hey, how are things going? You know, what's the approval process? How long is that going to take? I mean, they might need to have multiple meetings. It might need to have a board meeting. Who knows? But there's a lot of different reasons why it can take a while. But I think being consistent and following up to figure out find out where you are in the process. Okay, next slide. And just to wrap it all up, so the tips for a successful request is kind of my summary of everything I just talked about. Again, ensure your medical documentation discusses both the AT that you're requesting and any alternatives that might be possible, and discuss the issue. And you want to make sure that it describes that AT you're getting is medically necessary and cost effective. And then you want to provide proof of all those funding sources that you've been pursuing. Got to have that in the packet. And ensure all your documentation is complete. And please remember to sign everything before you submit it in. And then if you're denied, hopefully you won't, because you've done all your homework, got everything submitted, turned in just right. But if you are denied, you're going to follow the appeal process promptly. You don't want to waste any time. And with that, I'm going to turn things over to Anna, and she's going to start talking about the appeal process.
Thank you so much, Sarah. So we're going to go through what happens after you turn in your perfect packet and you get your denial anyway. And the AT denials happen for many reasons. And every beneficiary is entitled to a written notice explaining what the Medicaid service was that was denied and the reason for the denial. Sometimes these notices are not very specific. They might simply say not medically necessary or not cost effective, or the description might be pretty vague, and you might need to probe a little further to figure out what kind of documentation you really need to provide to support your appeal. But here are some possible reasons for denials. Most common one probably is lack of medical necessity. So the waiver agency has looked at the medical documentation and they say, nope, this is not medically necessary for you. This is kind of an optional thing and you don't need it to regain your functional status or for the independence or to achieve the goals in your plan of service. So for that, you're going to want to get medical documentation, and we'll get into that. The waiver agency might say, this is an excluded item. We can't cover this at all. And for that, you're going to want to look at the policy. Is it indeed an excluded item? Can you request it under a different type of service, like goods and services, for example? They might say, well, this kind of modification is only available through out-of-network providers. Sorry, no can do. And there are requirements to go out of network in some cases. So for that, it's worth to talk with an advocate. And I think we have a bit more info about that later. The waiver agency might say there's not enough documentation to support medical necessity or cost effectiveness. And if it's truly a documentation problem, that might not make it into the notice, but the reasoning in the notice might give you a clue that you need more documentation to convince them that this is indeed medically necessary. Or the waiver agency might say this is not cost effective, or a least cost alternative is available. And for that, as Sarah described, we want to educate the waiver agency about all of the costs associated with their identified least costly alternative to hopefully get something that is more appropriate for you. So let's go through the appeal process bit by bit. When you get your written notice of denial, you should appeal it, because otherwise you're just accepting that you're not going to get that piece of AT. And as Sarah mentioned, you might need to follow up a few times to get a notice. The processes are different at each waiver agency, and especially if you're getting multiple bids or if it's a big ticket item, they might need to take it to a board meeting, so it might be slow. However, there is a timeline for Medicaid service authorizations in our state policies, and that is 14 days. So technically, the waiver agency needs to make a decision within 14 days after you submit your request. If they don't make a decision within 14 days, it's considered a denial that you can appeal. Do you always want to appeal on day 15? No, right? If they seem to be moving forward and you're having a good cordial relationship, appealing might not be the best way to get the right result, because it might just make everything more contentious. However, if you feel that the process has stalled and you're just being brushed off and you're not getting any updates, you can appeal even without a notice if you've been waiting for more than 14 days after you put in your request. And that sometimes is what it takes to shake a decision loose and get an authorization, or at least more information about what it is that they need to authorize it. So if you're going to appeal, there are two main appeal steps. You have to do an internal appeal first, and then you get to do a Medicaid fair hearing in front of an impartial administrative law judge. And there's two appeal steps instead of the normal one, because both Habilitation Supports Waiver and MIChoice are managed care Medicaid programs. That means the waiver agency gets funding for each individual in the waiver, and then they kind of figure out how they're going to authorize services and pay for them within that. And so in that type of system, any denial has to be appealed with the waiver agency first, and they get to take a second look at it before you can appeal it to an impartial administrative law judge. So the internal appeals for the HAB waiver are with the CMH or the parent PHP organization, but you can just submit your appeal to the CMH. It'll get to the right place. With the MIChoice waiver, the appeal is with the MIChoice waiver agent. And either waiver agent is supposed to find an impartial person from somewhere in their agency to be the decision maker, but it's still from within their agency. And so this is more like a meeting and a second look than a real appeal in my mind. The deadline to appeal is 60 days from a denial. So again, if it's been 2 months since you put in a request and no decision is forthcoming, it might make sense to file an appeal, right? Because technically you've had a denial 14 days after you submitted the request. So that's kind of my rule of thumb. If you're not getting any movement within 2 months after putting in a request, it's probably worth filing an appeal. If the internal appeal is not successful, you get to appeal it to the next step up, and that's the Medicaid fair hearing. These appeals are before MORE, or the Michigan Office of Administrative Hearings and Rules. They're presided over by an administrative law judge that is hired by MORE and not by the waiver agent. And the deadline to appeal that is 120 days from the internal appeal outcome letter. So as you can see, it could take 6 months from when you put in the request if you're kind of waiting towards the end of each appeal period to get a final decision. If you're unhappy with your Medicaid fair hearing results, that is also appealable up to circuit court. That's the court in your county where like divorces and felonies and everything are heard. So it's just a normal court. Those appeals are tricky because you're stuck with whatever information the agency's had at the fair hearing stage. So if you are really set on getting representation potentially, on an appeal of a bad Medicaid fair hearing outcome, it makes sense to talk to that potential representation before you do the Medicaid fair hearing, because it and its appeal are kind of tied together. So let's talk about how you prepare for an internal appeal. And I'm going to focus on the internal appeal here and not the fair hearing for a couple of reasons. Number one, the documentation that you're getting and the arguments you're making are the same for both. And the other reason is that if you have a good relationship with your waiver agent, preparing really well for an internal appeal and coming at it collaboratively is much more likely to get you a good result than pressing into a more contentious Medicaid fair hearing. And also, this is the homework that you need to do in order to have a successful Medicaid fair hearing. So we're going to go over how you prepare really well for an internal appeal. And if that gets denied, I do recommend talking to an advocate at MI-UCP, calling Disability Rights Michigan, calling the Counsel and Advocacy Law Line for your local legal aid. The Medicaid fair hearings are more like court hearings. And while you are able to do them yourself, it's good to at least talk to an attorney or an advocate who's done them before. But internal appeals are just like really involved meetings with the waiver agent where you put everything in front of them and try and get to a good result. So we're going to focus on that. So when you get your notice of denial from your waiver agent saying we're not approving this AT, first you gather information on the denial reason. Then you prepare to respond to the denial reason. You collect and submit additional documentation. You can write and submit a statement. That is not necessary, but it is helpful. It does not have to be formal, but even just a bullet pointed list of why you meet all the criteria and which documents in your packet support that can be really helpful in framing the discussion when you do have that internal appeal. And you can prepare some questions for the CMH or the MIChoice waiver agent. If you really do not understand why it is that they denied you, the internal appeal is an opportunity to probe that and potentially prepare for a more productive Medicaid fair hearing if that's what it takes. So the gathering information stage. First of all, well, actually, the last bullet is probably the first one. Ask your caseworker, right? Especially if you have a good relationship with your caseworker. Ask them, why was this denied? Do you know what additional documentation could help? Was there something you guys were worried about? Is there an alternative device that you guys think I should be using? Ask your caseworker and have that conversation first so that you can start collecting responsive documents. But going back to the first bullet, you should also request the CMH or the MIChoice waiver agent to provide you copies of the documentations that they relied on in denying you the assistive technology or the DME. This is because they are required to provide those documents to you for free when they issue an adverse decision. That's a federal regulation, and I cited that here just in case there's any pushback, right? And that packet I find is really helpful because you can see a little bit of what was going through their minds and what matters to them. Is the packet just missing good doctor letters? Like maybe they just omitted them. Are there new documents in the packet that you did not give them? For example, printouts of other devices that it looks like that's what they want you to be using. Is there another medical opinion or, a policy or something like that that explains why they don't think something's medically necessary? So from talking to your caseworker, from looking at your notice and looking at the records that you received from your agency, try to identify what is the reason, right? We went through the different reasons like not medically necessary, not cost effective, out of network. Which one of these is the problem? So once you've figured out the reason or reasons, you can prepare to respond. If the reason is lack of medical necessity, look at your doctor letters. Look at the Medicaid provider manual. This is the manual that has all of the policies for Medicaid services in Michigan. And there are separate chapters for each of the waivers. So there's like a Habilitation Supports waiver chapter, a MIChoice waiver chapter. Each of the others has their own chapter. And within the Habilitation Supports and MIChoice waiver chapters, there are sections on the specialized medical goods and services. And it describes the medical necessity policies in those little paragraphs. And we do recommend you Google the manual and download it and look at the bookmarks on the right side to find the chapter that corresponds to your waiver and the service. We did not include sites to it here because it has changed all the time with no warning. And so every time I go to look at the manual, I Google it and I click on it afresh because sometimes there is a change that was just made last week and I want to get the most up-to-date policies. So go look at the Medicaid provider manual and look at your doctor's letters and see if all of the elements that are described in there are ticked off in your doctor letters. If the agency says this is an excluded item, look at the Medicaid provider manual for that type of service and see, is it indeed one of the excluded items? Because maybe that's just the discussion you need to have, right? It's not excluded. Let's talk about it. If the agency is denying it because the only providers are out of network and they're not approving it, or that there's an in-network alternative available, look at the documentation that they gave you about the in-network options, and what steps they took to secure, right, to get you the in-network option. If there's going to be a very long delay, right, many months to wait for an in-network option, that is a good reason to have to go out of network. So look at the documentation they have about trying to get in network first. If the agency says that your documentation is lacking, check to see, is it, right? Does the documentation you provided support medical necessity? Does it support cost effectiveness, right? As Sarah said, does it go through the cost of getting ready or compensatory services if you get a different, cheaper alternative? She gave examples of a different speech generator device that might be cheaper, but that you don't know yet. And so you have to have many hours of speech therapy in order to learn how to use the new type of speech generator device. But another example is if you're asking for a medicine dispenser machine that can notify your caregiver if you're not taking your meds, right? And if the agency is pushing a cheaper medication dispenser machine that maybe does not have that connectivity and caregiver alert, maybe you need to have home help services or somebody to come to every day to make sure that you're taking your medicines in order to be safe. And that would actually cost more than having, the extra $50 a month for the caregiver alert portion. That is something that a doctor could write a note about and say, if you take your medication 2 hours late, here are the potential adverse health effects. You need to take your medication on time. And therefore, you need to have either somebody there or a caregiver alert function on the medication dispenser. So that outlines the cost effectiveness because it explains what other service will be necessary together with the item that you're asking for, enabling the waiver agency to do the math themselves. If the documentation is lacking, maybe you got a letter from an OT, but your orthopedic surgeon is a better person to write the letter, or the agency is really looking for somebody with a medical degree, with an MD. Get the MD letter, right? It's not really worth going to a hearing and having an argument about whether the PT or OT is the best person to make this call when it is possible to get the type of documentation and the type of provider that the agency is looking for to write a letter. So consider that. And we discussed cost effectiveness a little bit, but if there is a least cost alternative somewhere in the records that you got from the CMH or the MIChoice waiver agent, or maybe it was mentioned by your caseworker, look it up, right? Talk to your providers about what it would mean for you to use that AT instead of what you're asking for and what they recommended. And compare the cost of that AT and the necessary therapies to get you going on that with the least cost alternative and the necessary therapies to get you going on that. Or additional surgery or treatments that you might need if you're getting that cheaper alternative and not what you asked for. So after you figured out what you need, collect it and submit it. And I wanted to flag one piece of Medicaid policy here on medical necessity, and it's medical necessity for kids under age 21. There is a section of the Medicaid law that says that kids under 21 kind of get whatever is medically necessary for them. And the only hard exclusion is for experimental treatments, and agencies are allowed to do prior authorizations. So request materials, documentation in advance. But apart from that, there's really no exclusion for what kids can get if it is medically necessary. And while the state can set pretty strict criteria for like how this AT will improve your functional abilities for adults, they can't do that for kids. For kids, the standard is, again, really broad. It's that it corrects or ameliorates a physical or mental impairment. So that that really opens the door for a lot of AT for kids. You are still stuck with the least costly alternative, right? So you do have to show that this is the most cost-effective way to correct or ameliorate that mental or physical impairment. However, if you are under 21, or you're helping someone who's under 21 and you're being denied some AT because it's not medically necessary, it is worth talking to an advocate about making this EPSTT, under 21 argument. And it's one that you should make yourself. Well, this is a kid. This is not an adult. The adult rules don't apply. Okay. So if you get a medical necessity denial for a child under age 21, push back. If documentation is lacking, you should look at the documentation you submitted and decide, is there a better provider to write a letter, or can my providers write a more specific letter? If cost effectiveness is the reason, you should get supplementary provider letters that discuss the additional therapies or interventions, including session estimates that would be necessary for the least cost alternative proposed by the agent. And the number of sessions is important because that's how you do the math. So you really work with your provider to get a really specific letter about what the alternative would look like for you. If you want, you can write and submit a statement. This is optional, but it can be really helpful. You want to respond to the denial reason, right? Whether it's medical necessity, out-of-networkness, or cost-effectiveness. And you want to quote the relevant criteria or definitions from the Medicaid provider manual. So you want to look up the chapter for your waiver, you want to look up the service that you're asking to have, and then you want to just put that in there in front of you so that you know and they know what the criteria are. And again, if you're helping somebody who's under 21, look at the EPSTT chapter of the Medicaid provider manual also. The very first few pages of that chapter, I think they're called like general information, go through what medical necessity for kids is and how it's defined. So you can copy out the definitions from there and really highlight for everyone in the room that for a kid, they get whatever is medically necessary for Medicaid. In your statement, you want to explain how the AT that you're requesting meets the definitions that you put into your statement. Ideally, you'd want to quote from provider letters and say, here's the criteria, here's what they said. And you want to estimate costs for additional therapies or interventions if a least cost alternative is used. For example, if you need like 20 speech therapy sessions and each one is $50, right? You put that in there. It's probably a lot more than that. If it's home help that you need to ensure that you're taking your medication on time, you know how much that is per hour, or you can ask your advocate and you do the math there, right? I need 2 hours of home help per week at least, and that is $28, and then that times 4.3, and look, that is already so much more than the monthly cost of the caregiver alert. And you want to close by explaining the risk of harm or loss of independence, or your inability to reach the goals in your plan of service without the AT. Even though that might not be the main reason that you're being denied, it is important to explain the consequences of their denial. Shame them. And then as you prepare for the internal appeal, you want to think, do you have any questions, right? Do you want to find out more information than what they've told you and what is in the documents so that you can prepare for a future appeal? And you can also prepare some broad questions to walk them through their decision to deny and ask them about good documentation in your record to encourage them to take a second look at it and hopefully reverse their denial. And so here I have some sample questions you might want to use. Can you please walk me through how you reached the decision to deny this? Who made the decision to deny? That's helpful to know because if you do go forward with a Medicaid fair hearing, you can request that that person is there as a witness. What medical documentation did the person who denied this review? And then, if you have really, really good documentation, how did this letter fail to establish medical necessity? Can you please explain this to me? And then just go through the letter together and have them, hopefully explain what is missing so that you can go back and get better supplementary documentation that directly answers their concerns. If cost effectiveness is the argument, ask, how did you calculate that this cheaper device was more cost effective? There might not be a good answer, but if there is, ask, did you consider the cost of additional therapies? Or I will need surgery sooner if I don't get this device. I mean, my doctor said that in this letter. Did you consider that? Because it's possible that they missed it. How did you factor that into your decision that this cheaper device is more cost effective, even with the surgery? And how did you determine that the cheaper device would meet my functional needs? If the person making the decision is not any kind of PT or OT, is not a medical doctor, it's possible that it's not based on their medical knowledge and not necessarily based on policy, and it's just kind of based on their preconceptions about what types of AT people are supposed to use. So it might help to walk the decision makers through your physical needs. For example, you want me to use this medical alert device, but if I fall, I may not be able to press a button, right? I don't have the muscle strength in my arms to get them out from under my body if I fall. That's why I'm asking for this to be voice activated. Sometimes walking somebody through that in person can be really helpful. So if the internal appeal is denied, so let's go back to what happens after this internal appeal. These internal appeals are usually conducted by Zoom, but they can be conducted in person. And it is really unpredictable who is present for these internal appeals. For example, I just had one out of Genesee Health System, which is a CMH, where the internal appeal was conducted by the parent organization, the PHP, and nobody from the CMH attended. So the PHP had all sorts of questions for the CMH, but there was nobody there to answer them. That was very strange. But that's an example of how these internal appeals vary so much from organization to organization, and approaching it as kind of a problem-solving, information-gathering meeting is the best way to go because you just don't know what it's going to look like. Most likely, your caseworker knows what accommodations you need to make the meeting work for you. But for example, if they try to schedule it by phone or you need an interpreter or something, and the way they're trying to schedule it does not work for you, make sure you ask for the accommodations that you need to make the meeting productive. So if you prefer it to be in person or by Zoom, or you need an interpreter, ask for it beforehand so that they can prepare. After the internal appeal, you get a written notice, again, of the outcome of the appeal. And the agency is supposed to write what decision they came to and why. But again, the why might be very, very sparse. So once you get the internal appeal result, if there is no documentation attached to it, you can ask for all documents that they relied upon to reach their internal appeal decision. And that might give you a better clue of what they looked at and how they came to the decision. But if you are denied, you do need to appeal to more in order to have a chance to get the AT that you want. And while I'm not going to go through more appeals in detail today, here is kind of the main overview of the process and how it differs a little bit from internal appeals. The appeal form for the more appeal for the fair hearing should be included in your internal appeal resolution notice. So the appeal or submitting the appeal is fairly straightforward. You just have to write, I disagree with the denial of my AT. It was denied again at internal appeal. I request a hearing. That's all you really need to say. I also recommend putting any technology accommodations that you need right there in the hearing request. There's a field for it, and then there's also open space where you can write. Because Medicaid fair hearings are usually by phone, if you want it to be by Zoom or in person, you want to be very specific about that. If you need an interpreter present or you have any mobility needs, put that in there to make sure that it's accommodated as early as possible. Once you request the Medicaid fair hearing, you will get a notice from MORE called a notice of hearing, and it will give you the date of the hearing. It will give you the hearing information, like the phone or the Zoom link or the address, and it will have deadlines in it. So here's what you look for. One is, when is the hearing, right? The dates. Two, how is the hearing being held? So if it's you request it by Zoom or in person and they scheduled it by phone, you need to get in touch with them when you get the notice and ask for it to be by Zoom or in person or whatever it is that you want, because phone hearings are awful and I do not recommend. Three, look at deadlines. So the notice, usually on the second page, will have deadlines for you to submit your exhibits, to submit your witnesses, and the contact information for the agency representative. So anything you submit both to MORE and to the agency representative. Make sure that you have things ready by the deadline, but if you miss it, just bring them to the hearing. Usually judges are pretty lenient for unrepresented people and will let you submit documents that you have with you at the hearing. As you're preparing, you want to identify the exhibits that you want to use and witnesses. For example, you might want your child's teacher, or you might want a doctor or a physical therapist there to testify and answer questions. Because while a letter is good, having them in person is better. And that individual might really want to be there to advocate for you, but their employer won't let them without a court order. So the way around that is to have the judge issue a subpoena. A subpoena is a court order to appear at a hearing or something. And so as an attorney, I am able to issue subpoenas, but non-attorneys can't. So what you do is you email MORE, and it will get to the judge, and you explain who it is that you want there and why, and their contact information. And the judge will issue you a subpoena, which is that court order for them to appear. You have to serve it on your witnesses, ask them how they need it. You know, I've had to serve them personally, which is the official way in the past, because school districts were very strict about it. But other organizations were fine with it just being sent by email and just being on file. So ask your witness how they want to be served. And finally, you want to prepare materials to file with MORE. And then you'll also be emailing them to the agency representative. You'd want to have witness and exhibit lists, just like 1, 2, 3, here are my exhibits, 1, 2, 3, here are my witnesses. That's required in the notice, but it's also really helpful so that everyone knows how long the hearing is going to be and who all else needs to be called. And even if a witness, you might be calling a witness, but you're not sure, just put them on your list. You can always make an 11th hour decision not to call a witness, and everyone will only be happy. But springing a surprise witness on everyone will upset everyone. You want to mark your exhibits. Usually petitioners like you would mark them 1, 2, 3. That just helps everyone sift through them, right? So it's like, I'm on page 2 of exhibit 3, and then everyone can just go there. If you have an updated statement, updated from your internal appeal, submit that. That would really help the judge get their head around your argument. And if you can cite to your exhibits and the doctor letters, that is really helpful. And finally, because a hearing is like a little trial, and if you don't have a lawyer, you are your lawyer, you will be making statements, but also eliciting statements from your witnesses, because any evidence that they provide has to come from them. And so you can prepare questions for your witnesses. You know, explain why I need this this AT. Explain why this will help ameliorate my child's physical condition. Like, what is their physical condition? How will this ameliorate it? What happens if they don't get it, right? And you can also write some questions for the opposing witnesses, like, you know, how did you consider this doctor letter in making the decision that this will not help me improve my function? Writing witness questions is tricky, and so I do recommend talking to your advocate or calling DRM about that. That is something that we help people with sometimes, is preparing for hearings, even if we're not representing them. So that brings us to Disability Rights Michigan. Do you want to talk a little bit about what calling DRM is like, Sarah?
Sure. When I first started out here at DRM, I worked in the information and referral department, and I still help out now and then. So when someone calls Disability Rights Michigan, they're going to go through the intake and information and referral. They'll speak with an intake specialist who's going to get a bunch of your information, your address, phone number, anything that you're willing to provide. Find out a little bit about what you're calling about, whether it be employment or education, any of the various issues I mentioned earlier. And then they will match you with an advocate who is kind of focused on that particular issue that you're calling about. And if the issue meets one of our agency's focus areas, that it might get run up the chain a little further to see if we might be able to provide some direct advocacy or legal assistance to help you support to resolve whatever issue it is you're facing. We've talked a lot today about appeals, but there's a lot of different things that we can help with. I work with folks helping them to gain access to their assistive technology. But I can also help people with requesting reasonable accommodations, accessibility issues. There's just a whole host of things that we can provide folks. And yeah, that's kind of my 2 cents on that.
I think that's the end of our presentation. So thank you everyone for listening. And I think we have maybe a couple minutes for questions.
I think you can go to the next slide, Anna, to give our contact information. There we go. So if you do want to talk to an advocate, give us a call. Our phone number's there and our web address.
Wonderful. Well, we do have some questions, so I will read those just the way they're written and y'all can address them if you're ready for that. Lovely. So the first one is, what is the typical turnaround time for an AT request?
I can take that one, I guess. From the point of when you start talking to your supports coordinator, your case manager about it, to the point where you get either approved or denied, it varies. If you're looking for vehicle modifications, that's going to take a bit longer. You're going to have to get all the bids, and if you don't already have the vehicle, you probably have to get that too. But like Anna said, they do have a 2-week time frame to respond once you submit all your documentation. So, to answer your question, I can't really answer it. It's different for each device and what's needed to support requesting that device. I've seen it take months and I've seen it take weeks. It just depends on how quickly you can get everything together and get it submitted.
Great. And the next one is, can the MIChoice waiver collaborate with another funding source for AT? For example, if a person needs vehicle modifications to get to work, but also needs those modifications for community mobility, could MRS, Michigan Rehabilitation Services, and the MIChoice waiver split the cost?
I don't know. Do you know, Anna?
No, for sure. And we can look into that. I know that MRS and CMHs have split the cost of attendant care, for CLS. So MIChoice provides some attendant care, and then for the work portion, MRS provides that. So it is possible, but I don't know about splitting the cost of a device. So we can definitely look into that.
Okay, so Claudette, will if you want to reach out to me and they provide that to me, I'll be happy to share that with you at a later date. Since you and I do speak occasionally, feel free to reach out to me. All right, so the next one is 14 calendar days for an answer or 14 business days?
14 calendar.
14 calendar days. Okay. The next question was, I have never had a caseworker. How or where do I go to get one?
You've never had a caseworker. Well, it would depend. Like I said, if you're interested in community mental health services, if that's a service you think you might need, you would contact the community health agency in your area. And if it's MIChoice, you would get a hold of the MIChoice agent in your area, which is typically the area agency on aging, but not always. You can go to the MDHH website to get lists of both of these, where your CMH is and your MIChoice waiver agent, and get in touch with them and then get a screening for services.
The next one is, if a device is denied due to cost effectiveness, but that particular device is the user's preference, can they pay the difference?
I don't think so. What, Anna?
I don't think so either. No, I mean, they pay for the device. They don't just give you money for it, unfortunately.
Okay. The next question is, I know you're talking specifically about the HAB and MIChoice waivers, but Anna mentioned the broader EBSDT definition of medical necessity. Is AT available under the children's waiver or 1915I SPA? And would this be a good strategy to use with kids getting services that way?
So I don't know off the top of my head whether AT is available under the children's waiver or the state plan amendment. That's the 1915I, but EPSDT law says that kids get whatever is medically necessary, whether or not it's like on the menu of services that is available for that child. If it's available somewhere in the state plan, then if it is medically necessary for the kid and it's the cost-effective option, they should be getting it. So EPSDT is just generally a good argument for kids. Yes.
Okay. The next one is just a compliment. You guys are amazing. Thank you for all the information.
Thank you.
And then, is the PowerPoint going to be available for attendees? It would be great to have as a reference. I put it in the chat earlier, the PDF of the presentation. I'll drop it again. Let me do it now before I move on so that, let me just make sure I've got everything in the right place to do that. 1 second here. I've rearranged everything to the point where that window's not right at the top. So 1 second. Chat. Okay, there we go. All right, so I'm going to pull it over there now, and it'll be available one more time in case you weren't on when the first one. There it is. All right, so that's done. Let me go back over. All right, so somebody also says, I agree with Cassandra. Thank you, Sarah and Anna. I do
Thanks,
have
Crystal.
something. I want to say, because I thought of this as we were going along, I get a lot of calls and do a lot of advocacy with people who tell me things like, but I already signed my plan of service. I had my PCP, my person-centered planning meeting. And what I tell them is life changes, your needs change, and you can ask for a plan of service at the time that you need that change addressed. So,
Absolutely.
so your your person-centered plan is not an annual. I know I'm just lecturing now, but this is a constant problem that people have when they contact me, and I just want to address that. A PCP is not an annual thing. It's based on need, and it's right there, and you can ask for one upon change of need. So do that at your time, at your convenience. Invite all the people that are involved in that person's life, and you can get an independent facilitator if you need one. If you feel like you want someone who will address your needs differently than maybe you've had in the past. So I'll go right out there and just put my thing, and I'll let Anna talk more about that if you have anything to add to that.
I just want to add that your needs don't actually have to have changed for you to ask for an additional service, and don't get gaslighted into that by the agency, because that does happen sometimes. If you didn't know that you could ask for something and now you know and you're asking for it, that is a valid reason too.
Yeah, you can request a planning meeting at any stage, and they have to provide it, and they'll discuss those needs. Like they said, needs change, and you might not even think of something you need until one day, oh yeah, that would be so helpful.
If you get confused when you're Googling for the Medicaid provider manual, it's usually, there's a link to it on the State of Michigan website as well. I tell families all the time, it's a big document. It's going to take a lot of memory to, to look at it there, but that's where all the significant things are listed. And here's the kind of the words to look for as you look through that process for your need.
Jump in on that. If anyone's trying to look up something in the Medicaid manual, Michigan Medicaid manual, and they're having a hard time, you can give us a call here at DRM. All of our advocates know how to jump in there. Some of us are probably a little quicker than others, but it's something that we have to deal with all the time, looking things up in the manual. So I've often just gone in and done saved a PDF of a couple of pages for someone on a certain chapter and then email it to them. So much easier than saying, no, you got to go and dig through the thousands and pages.
Yeah, it's a lot. And it's scary, especially if someone isn't sophisticated about the language. The language certainly can be a little daunting. I want to make sure that everyone knows if you need as an accommodation to ask your question aloud, please raise your hand, click the raise your hand button, and I will unmute you and you're welcome to ask. And if we'll give just a minute for somebody to do that, but we've addressed all the open questions. Any last thoughts from either of you that you've thought of that you want to address while we're waiting to make sure? Okay, someone's asking for you to share your contact information again. Maybe we'll put that slide up if you could one more time. Oh, and it would be on the document that I put through, the PDF document would have that slide with their contact information. So if you want to grab that out of the chat, you also could have the slide that has their information so you don't have to write it down.
I just put our main line in the chat. Oh no, that was not to everyone. Let me send it to everyone.
There you go. So that's out now as well. And put up the link to the Medicaid manual for the provider manual for everyone.
Thank you.
Wonderful. I don't see any more. So at this point, I'm gonna let you know that if someone missed this presentation that you think needs this information, in about a week, it will appear on our YouTube channel, which is MI-UCP on YouTube. So it will go up in about a week. It usually takes about a week for the recording to go there. And then let's see. I also want to ask you to please join us on August 14th at 10 a.m. for another AT topic to be presented. I don't know yet exactly what it'll be, but it will be on August 14th at 10 a.m., the second Thursday at 10 a.m. So someone says they got the link, but not the presentation. So if you want to reach out to me, I'm going to put my email in here for y'all, and you can reach out to me and I will make sure you get a copy of it.
Thanks, Tracy.
Sure. Anybody else have any questions or comments that they want to make before we sign off?
Yeah. Okay. Thank you guys for joining. Yeah.
Thank you both, and thank you all for attending. I learned an awful lot, so I so appreciate you both for spending the time to make it and to do it for us. I think it'll be a big help to a lot of folks. So thank you all for attending, and everyone have a great rest of your day.
You too.
Thank you.
Thank you. Bye-bye.